Hello, everyone. We're going to give people a few minutes to join, I guess another minute or so. Okay. Can someone from the team tell me if we have good numbers joining us? Should we wait another few seconds or should we get started?
I think we can get started.
Great, thank you. Hello, everyone. I'm Dr. Suzanne Buchanan, Executive Director of Autism New Jersey. I want to thank you all for joining us as we discuss an important topic for our community, the care and safety of individuals with developmental disabilities in group homes. The Hidden at Home series by NorthJersey.com and the Alone, Autistic, and Afraid report by NJ.com highlighted several cases of abuse and neglect in New Jersey's privately run group home system. Paul Aronson, New Jersey's Ombudsman for individuals with intellectual or developmental disabilities and their families, has been calling for massive reform for years. Just this past week, both candidates for New Jersey governor said that the state needs stronger enforcement against poorly performing group home providers. There's outrage and heartbreak across New Jersey's autism community, including here at Autism New Jersey. For 60 years, our organization has fought to ensure safe and fulfilling lives for individuals with autism and their families. Autism New Jersey supports several bills to improve group home oversight. These measures would enhance the enforcement authority over service providers, revise the definition of child abuse or neglect to include persons 18 to 21 in certain settings, and create a committee that would review cases of abuse, neglect, exploitation, and deaths, and recommend ways to prevent future harm. As our policy team collaborates with legislators on these measures, we want to thank those of you who submitted questions when you were registering for this webinar. Every question submitted helps us plan future content as well as our conversations with state leaders. The goal of this webinar is simple. It's about having a shared understanding of the investigation process as it is today, or as it is supposed to be today, and this shared understanding is a fundamental step toward change. Before I introduce today's speakers, I'd like to take a moment to acknowledge the strong emotions everyone feels, and we're all right to feel them. There's nothing more important to me and everyone on this call than protecting those who cannot protect themselves. Years ago, one of my first work experiences was with children and teenagers with developmental disabilities and severe challenging behavior in a residential setting. I was in my 20s and was closer in age to the teenagers I was working with than their parents. There wasn't a morning, day, or night that I didn't think about what it was like to be them, what I imagined they might be feeling, maybe confusion, anger, fear, sadness, and loss. So every morning I would greet every child with a smile and a deep warmth. Every day I would do my level best to understand their challenging behavior and help them learn new skills. And every night when I went home, I was hoping they knew and they felt that their families loved them beyond words. I also tried to take the perspective of a parent, but not being a parent yet myself, I couldn't fully understand. A few years later, when my kids were born and they were so clearly vulnerable, I got it, at least on some level. I got it. Protecting other people from harm is one of the most fundamental things we can do as human beings, and why I and so many others have dedicated our careers to your children. And we all need to figure out how to do this better together, which brings us to today's agenda. Okay, I see the first item, welcome remarks, done. Now we can move on to our first speaker. One of the most important people in this endeavor, someone who can tell us how the state investigation process works, is our first speaker, Deborah Robinson, Director of the Office of Program Integrity and Accountability, or OPIA, within the New Jersey Department of Human Services. With a staff of over 200, OPIA includes the offices of licensing, investigations, incident management, background checks, and others. OPIA also manages New Jersey's central registry of offenders against individuals with developmental disabilities, the DHS risk management system, and the licensed provider report card, all vital components in ensuring accountability and the highest standards of care for New Jersey's most vulnerable residents. Thank you for being here, Deb. Please come on camera.
Thank you for having me, Suzanne.
Of course. I'd like to start with a question about you and your career. How did you get started in this work?
I think I always knew this was what I was going to do as a um, young person in high school and junior high. I babysat children with disabilities. I volunteered at local organization on my days off from school. So it was just something I was naturally drawn to. So when I became an adult, I worked for 18 years in a variety of settings early in my career: schools, day programs, residential programs, in a variety of different capacities: clinician, supervisor, quality staff, always supporting people with challenging behaviors. Um, and that has always been kind of something that I am very interested in and can appreciate. I began
We have that
working
in
for,
common.
excuse
I'm
me?
sorry. I was saying we have that in common.
Yeah, we do. I know when you were talking, I was thinking a lot about my early years as well. So it was very nice. I began working for the state of New Jersey 25 years ago as a DDD case manager, and then several other positions and roles at DDD before joining OPIA in 2014.
Wow. So you've been with the department for 25 years.
Yeah.
Incredible. Um, why is this work so important to you, and what keeps you motivated?
Well, families entrust their loved ones' care to others. And I understand how difficult and scary that is. So I think the work that OPIA does, monitoring and overseeing the delivery of those services, the people who are providing the care, the safety of the environments, holding people and providers accountable is really important work. But I think what motivates me is that it's never enough. There's always more that can be done. And I'm always looking for ways to change, improve, and grow so that we can better serve New Jersey families and individuals and keep people safe and especially free from abuse and neglect.
Absolutely something else we have in common. So moving on to our first official slide here, can you explain where OPIA sits within the Department of Human Services and how it relates to DDD?
Sure. I think a lot of people think that OPIA is a part of DDD, but OPIA sits within DHS's central office outside of any of the divisions. We have several units within OPIA, and all of which provide a layer of safety for people receiving services from DDD and the other divisions.
Can you speak more about the units that are under OPIA that might not be directly related to investigations, but still help ensure health and safety?
Sure. The Employment Controls and Compliance Unit manages the required fingerprint background checks for all DDD community and facility employees. It also oversees the DHS pre-employment and random drug testing program for DDD community employees. That requirement arose from the Stephen Kaminos law, which was passed in 2018. ECCU also manages required checks of the child abuse record information or carry check for all DDD community employees, regardless of their position of title. And that's also was established in 2018. ECCU manages the Central Registry of Offenders against individuals with developmental disabilities. That registry is important as it identifies caregivers who have been determined to have abused, neglected, or exploited individuals in their care and bars them from future employment. Also within OPIA, the Office of Licensing inspects and licenses community residences for people with IDD and also those with traumatic brain injury, with a focus on safety, supports, and the environment. OOL also offers technical assistance to help providers meet all the state licensing requirements and promote best practices in care. We also have the Field Safety and Services Unit. This is another unit that arose from the Stephen Caminos Law. The FSSU staff conduct unannounced visits to every DHS licensed home at least twice each year. The visits focus on any indications of abuse, neglect, or exploitation, cleanliness and safety of the home, staff interactions and support, medication and medical equipment use, medical care and follow-up, adherence to service plans, the food supplies, diets, special diets, and really the overall well-being of individuals. They do both an individual assessment and a program assessment during their visits. After a visit, they reach out to the provider with any concerns or findings that they had. Sometimes that results in an incident report. Sometimes they have to contact the provider immediately if there's a serious concern that needs to be handled right away before they leave. And then they require service providers to follow up with them for the concerns that they've identified. If we see repeat issues, those sometimes are shared with the Office of Licensing to take further action.
Can you talk now about the offices within OPIA that are more directly involved in the investigative process for abuse and neglect?
Sure. There are two larger offices in OPIA that handle the incident management and investigations. The Office of Performance Management, which consists of the Critical Incident Management Unit and the Incident Verification Unit, and the Office of Investigations. So if an individual receiving services from DHS is hurt, neglected, or otherwise placed at risk, that situation must be reported. This includes physical injuries, emotional abuse, or any events or serious events that could affect an individual's safety. Once reported, the incident is reviewed by staff, trained staff, and appropriate actions are taken to protect everyone involved. And CIMU oversees that process. So less serious incidents of abuse, neglect, and exploitation, along with some other incident types, are routed to the Critical Incident Management Unit, CIMU. In those cases, the provider is required to follow up, usually by completing an internal investigation, which gets submitted to CIMU for review and closure. For certain injuries or allegations, a state staff member from the Incident Verification Unit visits the person within 48 hours to ensure the individual is safe and the incident was accurately reported. And the most serious incidents of abuse, neglect, and exploitation are routed to the Office of Investigations. Most of these cases are assigned directly to OI, but in some cases, incidents can be referred to them after a further review.
And specific to CIMU, can you speak to some of the activities that it's responsible for?
Sure, some of the roles within CIMU, so they facilitate the appropriate tracking, management, and response to all reported incidents. CIMU is the authority of incident management. They administrate the New Jersey Incident Management and Reporting System, which we call NJ-ERMS, or ERMS for short. They also administer and put together the DHS Risk Management System and the accompanying licensed provider report card. And they also conduct administrative reviews on incidents that route to CIMU for closure and are followed up by the providers. So incidents that are routed to CIMU are investigated by the provider agency and then reviewed by CIMU. I know many people have asked, why is the provider agency responsible for the investigation?
Yeah.
And improving safety requires ongoing collaborative efforts led by the providers. Through incident reporting and investigation, agencies can identify and correct unsafe conditions, learn from their mistakes, and strengthen their culture of safety. This continuous process helps prevent future incidents and promotes higher standard of care. We really think it's a great learning opportunity to identify gaps and issues that the agency can then correct to prevent future occurrences. So once the investigation is completed, the provider agency sends it its report to SIMU for review, and SIMU performs a very thorough review for quality, completeness, ensuring that the provider's investigation includes all the key elements. They also ask for documentation of evidence to support the provider's findings. And there's often a lot of back and forth before an investigation report is accepted. And once accepted, the incident can be closed. And providers at the conclusion of the investigation are required to send the guardian or family member in writing the outcome of the investigation.
Okay. And when does IVU get involved, and what are they looking for?
So IVU responds to incidents that involve a moderate or major physical injury or abuse, neglect, or exploitation. So they complete in-person visits to the individual within 48 hours of the report. They meet with the alleged victim, verify the injury level, and confirm that safety measures have been taken. They also ensure the accuracy of the information in the original report and notify the provider of any changes to the injury level. So sometimes they change the code, they change the type of injury, depending on what they find when they do their visit.
And when incidents get routed to the Office of Investigations, what do they do?
So the incidents that get routed to the Office of Investigation are really the most serious incidents of abuse, neglect, and exploitation. However, that doesn't mean that there must be a serious injury or that serious harm was caused. OI also investigates egregious allegations of abuse and neglect where no harm occurred, but the potential is there. So certain incidents require reporting to the police. In those cases, OI works closely with law enforcement and the Division of Criminal Justice and county prosecutors who determine whether criminal activity is needed. Guardians are notified of the investigation via letter and phone call from the assigned OI investigator, and guardians are invited to attend the interview with their loved one. The investigator will schedule the interview at a convenient time for the guardian, explain the process, maybe have a pre-meeting to address any questions they may have. At the conclusion of their investigation, OI completes a report of findings and communicates the outcomes to everyone who needs to know. OI also makes the referrals to the Central Registry of Offenders based on their investigations. So as we mentioned before, in some cases, employees are referred to the Central Registry, which bars them from working with individuals with developmental disabilities.
And how does OI conduct their investigations? Can you walk us through that process?
Sure. So it begins with notification, again, to the guardian and the provider agency. We spoke about guardian involvement, how they can be involved in the interview with their loved one. They also receive the investigator's contact information at the start of the investigation, and the guardian is encouraged to reach out throughout the investigative process. So for the investigative activity, initially what happens is the investigator and their supervisor conduct an initial case conference and develop a plan. The investigator will visit the location, interview all relevant people, anyone who has any knowledge of what may have happened or knowledge that correlates to the incident. They collect documentation and evidence such as video, photographs, medical records, house logs, medication administration records, staff schedules, training records, even body cam footage, 911 call recordings, anything that they can find to help confirm what happened at the time of the event. The supervisor and the investigator have periodic case conferences throughout the duration of the investigation, and they work closely together to make sure they hit all the right things. The investigator submits draft reports every 15 days, which are reviewed by the supervisor. Although I think the supervisors really do review much more than every 15 days because they have access to all the investigative activity in one of our web applications. And then depending on the case, either the OI chief and or director may also review at certain intervals and before it can be closed. Sometimes we have lawyers on staff, sometimes we consult with them, and a newly hired medical director who we consult with on medically involved cases. So findings, the goal is to come up with a finding of the allegation. Findings are based on a preponderance of evidence standard, which means that based on the investigation, an allegation or incident is more likely true than not, or a 51% likelihood. Guardians will receive a detailed finding letter at the investigation's conclusion that will include a summary of the allegation or incident, the investigation finding, whether it was substantiated or not, an explanation of the finding, detailing all the evidence that supports the finding, any steps or actions taken to protect and support your family member. If law enforcement involved, they'll also include any criminal prosecution that happens. Even though it's separate, if we know the outcome when we finish our investigation, we'll include it in the letter. Whether or not a case is substantiated, if OI identifies concerns, the provider must submit a corrective action plan to address each concern, improve care, and prevent future occurrences.
Great, thank you for that. Can you talk specifically about any steps you are taking to improve transparency?
Yeah, we recognize the critical importance of transparency, especially within the complex framework of regulatory oversight and stringent legal standards. We're always looking to improve and are supportive of legislation introduced by Senator Vitale, which aims to strengthen the tools we have to hold providers accountable when adverse outcomes occur and to enhance the review process that safeguard people with disabilities. We're actively working to increase transparency and accessibility. We understand the desire for people to have more information about what we do. So in response, we are developing a refreshed website. It will include resources specifically designed to inform individuals and family about our work and provide valuable information to providers. We are going to share data and newsletters with tips for prevention. And through these initiatives, we hope to build a more informed community and foster safer, more supportive environments for everyone involved. Our website should be live in the next week or so.
Oh, that's great.
You can check it out.
Okay. Thank you so much for the formal part of the presentation. We have a few follow-up questions that are based on the questions that were submitted when folks registered for the webinar. So the first one is, how does OPIA ensure its investigations are independent, objective, and free from bias, given DHS's dual role in funding and oversight?
So as I mentioned before, OPIA sits within DHS central office and is apart and separate from DDD. DDD and Medicaid oversee funding and service provision. So OPI has no intersect with funding. As far as oversight, OPI is the licensing authority and has oversight over incident reporting, management, and investigations for the department, not just DDD. Also, everything OPIA does is regulated in statute or law, or for the purpose of meeting state and federal requirements. So as far as bias, as state services, we are bound to ethical standards, including formally recusing ourselves from any interactions where a conflict may exist. As I described in the investigative process, investigators are not autonomous. Frequent and ongoing case review at 2 to 3 supervisory levels, in addition to our structured and defined investigative format, I believe help to cull out any inadvertent bias. There's zero advantage for us to favor a provider. We have a strong team of investigators, and I'm really humbled by their dedication and commitment. And I can assure you the investigators in OPIA want nothing more than to find the truth, find out what happened, and they do use every available avenue to get there. When there's a lack of evidence or we can't find answers, they are more disappointed than some of you may think.
Yeah. Another question from the community is, what mechanisms hold OPIA accountable for the quality of its work?
So the Office of the State Auditor within the Office of Legislative Services has a responsibility to audit government agencies to ensure that compliance with standards are met and internal controls are in place. And few of our units have been audited by OLS in the recent past. Disability Rights New Jersey, New Jersey's protection and advocacy system, often does their own investigations into allegations. They are very in tune to what's going on out there. We work very cooperatively with DRNJ and are responsive to their requests for information, including our investigation reports. And also, every incident that's assigned to the Office of Investigations is automatically sent to the Division of Criminal Justice in the Attorney General's office for review. They follow some of the cases, they request our completed investigation reports, and make a determination whether they will refer a case to a county prosecutor or another state investigatory entity.
Okay. Another question from the community: how are patterns of abuse and neglect in certain sites identified, and what methods are used to address them?
So from a systems level, the DHS risk management system really includes the data behind the accompanying published report card. It gives us an opportunity to look at providers as a whole, compare them to one another, and identify indicators of patterns or problems. I chair the Council on Systemic Risk, which meets every quarter and is made up of senior level staff from all areas in the department and division. We review the data thoroughly every quarter in detail and look for emerging trends. We discuss the trends and plan a course of action when warranted. On a more granular level, though, all cases of abuse and neglect are handled by either the Critical Incident Management Unit or the Office of Investigations. The first thing that SIMU or OI investigators do for every assigned incident is what we call an search. They search incident history for the people involved, the agency, and sometimes even specific sites. SIMU staff each have a caseload of a number of providers. And this is really critical for early detection of patterns because they see all of the providers' incidents on a fairly regular basis. So they're really keen on picking up when patterns of abuse and neglect are present.
Mm-hmm.
And then they quickly meet with the provider, sometimes with their supervisor, meet with the provider agency. Sometimes we involve DDD, their clinical resource or other resource teams, and sometimes they involve the Office of Licensing. We also routinely run several reports with up-to-date data so that we can keep an eye on things like repeat victims, major injuries, several other reports. And these reports are reviewed by our prevention team, who takes a closer look and deeper dive into when they see patterns of abuse and neglect. And they can make recommendations or referrals to an agency or to another unit within OPIA or DDD. We also hear from families a lot, increased outreach from families. We'll also prompt a review of abuse and neglect cases, sorry. The Incident Verification Unit and FSSU are out in the field every day, meeting with people, checking on things, visiting programs. So we have about 30 OPIA staff in the field every day. We really think of it sort of as our eyes on the ground to get really current information. And they often also are able to point out trends and patterns that they see. So that's been really, really two great additions to OPIA as far as us identifying problems quickly. When patterns are identified, we work with the provider to identify precursors or antecedents. We look at all the actions taken thus far in response to determine if maybe other interventions might be necessary or more effective, or if additional resources could be helpful. And basically, we guide them through a root cause analysis, right? Define the problem, collect data, identify potential causes, find the root cause, and implement and monitor solutions. In some cases, we will initiate what we call a quality management team, and that's made up of staff from OPIA and DDD. And that team will provide strict oversight when a provider is experiencing challenges in this area or other areas. It usually includes halting admissions, a quality improvement plan, and close monitoring from the department until the data points towards systemic improvements that we think can be sustained.
Great. Deb, thank you so much for your time and for everything
Thank
you're
you.
doing. We truly, genuinely appreciate you and your entire team. Everyone there is a critical part of the safety net. So thank you. Thank you so much.
Thank you. And again, thank you for having me. It's been a pleasure.
Of course, to be
Thanks.
continued.
Yes, definitely.
And now we'll hear from Doreen Yannick, Director of Autism New Jersey's Law Enforcement Initiative, which is increasing the adoption of autism-friendly practices in police forces across the state. Doreen brings 28 years of law enforcement experience and more than 34 years of legal experience. She retired from the Union County Prosecutor's Office, where she served in numerous leadership positions, including as Deputy First Assistant Prosecutor and First Assistant Prosecutor. Doreen, take it away.
Thank you. Good afternoon, and thank you again for the lovely introduction, Dr. Buchanan, and thank you, Director Robinson. And welcome again to all of the attendees. We truly appreciate your interest, support, and desire for answers. Today, I will be providing an overview of the criminal prosecution and investigation portion of abuse and neglect allegations. In addition to OPIA's investigations of such conduct, there may also be prior or subsequent investigations conducted by law enforcement to determine whether the alleged acts rise to the level of criminal charges. Depending upon the nature of the conduct alleged, law enforcement's investigation may take precedence over OPIA's investigation. In essence, OPIA may be told to stand down so as not to inadvertently impede the criminal investigation. The integrity of the criminal investigation must be preserved. Now, potential criminal charges that range a wide array, actually, from disorderly and petty disorderly persons offenses, which are handled in municipal court system, to the more serious indictable or decreed crimes handled in superior court. The main differences between the municipal and superior court systems include severity of charges, court procedures, and sentencing consequences. Now, every town in New Jersey either has their own municipal court or shares one with a neighboring town. In municipal court, there is no right to a jury by one's peers. Rather, the municipal court judge serves as what we call the trier of fact and makes the ultimate decision regarding guilt. Additionally, in municipal court, there is no grand jury involvement, and custodial sentencing is capped typically at a maximum of 6 months. Examples of disorderly and petty disorderly persons offenses heard in this arena and which are most applicable to today's discussion include simple assault and harassment. In Superior Court, where the law division is based in the county seat of each of the 21 counties, an indictable charge may only proceed following a grand jury indictment, and unless waived by a criminal defendant, all trials are by jury. Additionally, the sentencing options in Superior Court are much weightier. As you heard earlier, following OPIA investigations, certain allegations of potentially criminal conduct occurring within group homes or other DDD settings are referred to the criminal justice system. Note again, however, that depending upon the circumstances, a criminal investigation could take place prior to the internal OPIA investigation. Referrals by OPIA to law enforcement come in several forms, which include 1. Serious allegations of abuse requiring immediate and mandated reporting to law enforcement, as Director Robinson referenced. Secondly, allegations of abuse or neglect which are substantiated by OPIA and referred to the Attorney General's office, specifically the Division of Criminal Justice. And finally, violations of what is known as Tara's Law. Now, I'd like to work backwards and focus first on Tara's Law. You may ask, what is Tara's Law? And it is and was a much needed legislation, which was enacted in 2012 following the tragic death of Tara O'Leary, a 28-year-old woman with developmental disabilities who died from starvation and neglect while residing in a state licensed facility. The law named for Tara established mandatory reporting and referral procedures for case managers, supervisors, caregivers, or volunteers in a licensed or state-funded group home, imposing very strict reporting duties and penalties for noncompliance. More specifically, any person identified in the roles I just referenced who has reasonable cause to suspect abuse, neglect, or exploitation, including but not limited to serious incidents such as death, head injuries, fractures, burns, internal wounds, bites, or injuries requiring hospitalization, must immediately report the matter to the Department of Human Services by phone or other means. Failure to report may result in internal disciplinary proceedings and, thanks to Tara's Law, criminal consequences. If DHS investigates and finds credible evidence by a preponderance of the evidence that a case manager, supervisor, caregiver, or volunteer failed to properly report, the matter is referred to law enforcement for criminal investigation and prosecution. Once reported to the Attorney General's office, which oversees all 21 county prosecutors' offices, and following their initial assessment and review, the AG's office will refer the matter to the county prosecutor's office having jurisdiction over the site of the alleged crime. Depending upon the given county's standard operating procedures and the nature of the abuse which is alleged, which was not properly reported, the investigation may be conducted either by the municipal department, overseen by the county prosecutor's office, or conducted by a specialized unit within the prosecutor's office. Upon investigation by law enforcement, and if probable cause exists that a case manager or supervisor violated the mandatory reporting requirement under Tara's Law, they may be charged with a fourth-degree crime or a third-degree crime, a more serious crime, if the conduct tragically resulted in death. Other caregivers or volunteers may face disorderly persons offense charges, as we previously discussed in municipal court. Returning to the topic of allegations of abuse and neglect, law enforcement again may conduct a criminal investigation either prior to or subsequent to a substantiated referral by OPIA to the Attorney General's office and then to the appropriate county prosecutor's office. Criminal investigations may occur if law enforcement was immediately made aware of the incident because the alleged actions mandate immediate law enforcement notification by DDD, DHS, or OPIA, or if the conduct was so serious that it required law enforcement or other first responders' on-site response, or if the actions required hospitalization, or if the abuse and neglect was so egregious that the alleged perpetrator clearly poses a risk to public safety. Again, depending upon the given county's standard operating procedures and the nature of the abuse alleged, either the municipal police department or a specialized unit within the prosecutor's office will conduct the investigation. Now, any such criminal investigation will require, to the extent possible, formal interviews and recorded statements of the victim and any relevant witnesses. Law enforcement may also seek, and typically does seek, a statement from the accused. However, the accused may assert their Fifth Amendment right against self-incrimination and invoke their Sixth Amendment right to an attorney, which effectively ceases further questioning. Other evidence, including video or audio recordings capturing the alleged incident, body-worn camera footage of responding law enforcement officers, photographs of any fresh or healing injuries, crime site photos, medical records, or other forensic evidence may also be gathered. Once the investigation is complete, the matter is reviewed by a lawyer within the prosecutor's office, known as an assistant prosecutor, to determine whether any criminal charges should be pursued. While the standard for issuing a criminal complaint is probable cause, assistant prosecutors must also view the case through the lens of their ultimate standard of proof at trial. That is, every element of each of the crimes charged must be proven beyond a reasonable doubt. Juries are instructed that a reasonable doubt is an honest and reasonable uncertainty in one's mind about the guilt of the defendant after full and impartial consideration has been given to all of the evidence. Proof beyond a reasonable doubt is proof, for example, that leaves one firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. This is the highest standard of proof in all legal matters due to the fact that it may involve incarceration and the loss of one's liberty. Moreover, any guilty verdict must require a unanimous jury verdict unless the accused had previously waived a jury trial. County prosecutors are required to notify the Attorney General's office of how certain referred matters are resolved. That is, whether criminal charges were filed or criminal charges were declined, with an explanation and justification as to the ultimate decision. This adds another level of scrutiny to that decision-making process. Abuse and neglect allegations can fall under various charges within New Jersey's criminal code known as 2C and under Title IX of the revised statutes. Depending upon the nature of this conduct alleged, these charges can range from simple and aggravated assault to sexual assault, criminal restraint, reckless endangerment, murder, and manslaughter. If following an investigation, a criminal complaint is issued, the complaint can either be issued as a summons or a warrant. Unlike a summons, the accused, now criminal defendant, can be taken into custody on a warrant. A determination is ultimately made by a judge as to whether a defendant will be detained pending resolution of the case or whether the defendant will be released back into the community on what is known as pretrial supervision. There are very, strict statutory guidelines determining whether a defendant can be detained pretrial, with priority given to those cases involving detained defendants. It is not unusual for a criminal case to take between at least 1.5 years to 3 years to reach resolution. I'm sorry, bear with me. So sorry. A criminal complaint can only move forward if a grand jury, which is basically a body of 23 jurors, after hearing the state's case, returns an indictment and determines that there is enough uncontroverted evidence to move the case to trial. Now, all of this sounds relatively straightforward, but certain barriers do exist to moving forward with criminal prosecution. And what are those barriers and how should we frame them and can they be overcome? Well, I would note that criminal investigations can be a lengthy and time-consuming process. As opposed to barriers, I would rather consider them to present more as legal challenges and legal challenges that could potentially be overcome. And what are those challenges? Well, there may include the ability to obtain sworn recorded statements from victims and witnesses and potential barriers to getting those statements secured. If there is a potential for an indictable crime to be charged, prosecutors can issue grand jury subpoenas to ensure witness response and hopeful cooperation. Identifying reliable witnesses capable of detailing their observations may unfortunately be hampered by delayed reporting of the incident or a witness's cognitive abilities and communication deficits. Law enforcement investigators may also face challenges in gathering relevant video and audio evidence. Excuse me. I'm so sorry, I'm getting over a cold. There might not always be video and audio recording capturing the event, or the quality of such footage may be poor. In instances where eyewitnesses are to be relied upon and those eyewitnesses are under care, and there is a need to assess their credibility as witnesses, investigators may face challenges in obtaining their medical information and treatment records to rebut likely defense claims that the witnesses are not reliable. The ultimate challenge is, as discussed earlier, the recognition of the higher standard of proof attached to criminal cases. That is, prosecutors again must prove each and every element of each of the charged crimes within the indictment beyond a reasonable doubt, with the ultimate requirement of a unanimous verdict of guilt at trial. Now, support for victims, and I hope you apologize my need for water. Support for victims is a significant part of the criminal process. This is particularly the case since competent victims are required to testify at trial if the case is not resolved by way of a guilty plea. This can prove, and the entire circumstances surrounding it and the entire process of having a victim or witnesses testify at trial can prove to be very daunting for that victim, for that witness, and their family. By way of a New Jersey constitutional amendment and a dedicated statute, victims of crimes do possess certain rights. The Victims' Bill of Rights states that a crime victim shall be treated with fairness, dignity, compassion, and respect. They shall be informed of the criminal justice process and decision-making, advised of court dates and final disposition, as well as their right to speak at or submit a victim impact letter prior to sentencing. Victims and their families are to be informed of available remedies, financial assistance, social services, and they're allowed to be compensated for loss sustained whenever possible, and to consult throughout the process with the prosecuting authority. The Attorney General's office and each of the county prosecutor's offices have a victim witness unit with advocates dedicated to assisting victims and their families throughout the criminal justice process. Now, Autism New Jersey, through its law enforcement initiative, has sought to encourage the adoption of autism-friendly practices by law enforcement to create supportive environments and to allow for effective communication during encounters with persons with autism or IDD. In fact, law enforcement engagement at group homes is the focus of one of our 4 topical subcommittees, specifically our Home Engagement Subcommittee. The initiative has drawn broad support from the Attorney General's Office, the County Prosecutors Association of New Jersey, the New Jersey State Association of Chiefs of Police, and the New Jersey State Police Benevolent Association. Through the work of our dedicated Law Enforcement Advisory Committee and Autism New Jersey's Power of Connection, great strides have been made regarding autism awareness within law enforcement and appropriate law enforcement response in times of crises. It is our sincere hope that these efforts allow individuals and their families to achieve a level of comfort with law enforcement and the criminal justice process as a whole, and something we continue to work on every day. Thank you.
I'm coming back. Here we go. Oh. Okay. Thank you so much, Doreen, especially as you're struggling through getting over a cold. If you need more water, let us know.
Sorry.
If you're still good, we're going to throw a few follow-up questions your way. Okay.
Absolutely.
So number one, and this is one of the biggest questions we received from people registering. How do communication difficulties among individuals with autism impact the ability to gather evidence and secure testimony?
Very good question. So part of any criminal investigation includes the interview and recorded sworn statements of victims and or witnesses, as I previously referenced. Criminal complaints will not be issued absent these sworn statements. So the ability of a victim to recount events in a clear manner and to answer questions of an investigator or detective in the interview process is crucial. In cases where the victim is unable to communicate or is otherwise incapacitated, the prosecution must rely on other evidence, including eyewitness testimony, video or audio evidence capturing the crime, as well as forensic or medical evidence, to the extent that such evidence exists. Now, regarding prosecution, I think I previously mentioned that every criminal defendant does have a Sixth Amendment right to confront the witnesses against them and have the witnesses be made available for cross-examination at trial. The confrontation clause in our Constitution is a critical component of a criminal defendant's due process rights, and it is essential for ensuring a fair trial. Now, the clause was designed to prevent convictions based on out-of-court statements without the defendant having the opportunity to question the witness's honesty and accuracy. Therefore, live testimony at trial by the victim, by the witness, is required. A previously recorded sworn statement obtained during the investigation process cannot substitute for live testimony at trial, as it would violate the defendant's right to cross-examination. It is not sufficient for the witness or victim to only answer the questions asked by the prosecutor. Rather, the victim or witness must also answer those questions posed by a defense attorney. And those lines of questioning, based upon my experience, can frequently be very rigorous. So to meet this constitutional right and to ensure a fair trial, a victim or witness must be able to testify at trial and communicate either directly or through an interpreter their observations and thoughts in a way that the court and jury can understand. New Jersey Evidence Rule 601 in particular requires that all witnesses, including victims, be competent. Under New Jersey law, witnesses are presumed to be competent. However, when a concern arises, the rule requires a witness to possess the abilities to, first, recall events, secondly, communicate in a manner which is easily understood by the court and a jury, third, to be able to understand the difference between the truth and a lie, and finally, to have the ability to swear to an oath or to affirm their testimony. Absent eyewitness testimony, video surveillance, or forensic evidence, this requirement does pose a significant barrier to prosecution if a victim is nonverbal or otherwise unable to communicate. So following a preliminary competency hearing where the witness or the victim is required to testify, a judge will determine if the witness meets the requirements of New Jersey Evidence Rule 601. When assessing a witness's capacity to communicate and understand the duty to tell the truth, the court may evaluate factors such as, again, a witness's ability to recollect events they have experienced, their ability to communicate effectively, and again, their understanding of the difference between truths and lies. If the judge does find that the witness is competent, then that witness will be qualified to testify. Issues with credibility are then handled through cross-examination, allowing the jury to decide what weight to give that testimony. If the witness is found to be incompetent, their testimony will be excluded. Now, none of this and none of these legal challenges or potential barriers should be interpreted to mean that prosecutions involving victims with serious cognitive or communication impairments are not pursued. Rather, this is a general outline of challenges faced by law enforcement and prosecutors in these types of cases.
There's so many challenges. So once OPIA substantiates a case, what are the main barriers to moving forward with prosecution?
So again, I think during my initial presentation, I addressed some of these potential barriers, which include, again, the ability to obtain sworn and recorded statements, the ability to ensure that the witnesses are competent and can communicate in an effective manner. I'm so sorry. And the ability to gather other evidence, which could be crucial if your victim is incapable of testifying or effectively communicating what they've experienced and what could be potentially criminal in nature. So again, that would be photographic documentation, medical records, treatment records, video evidence, any audio evidence, body-worn camera footage of responding officers. Detectives, again, will frequently do site visits, that is the site of the alleged crime, to get a better idea of where this is alleged to have occurred, where they will also take photographs or videos. So some of the barriers could be trying to obtain that information in a timely way, and that's sometimes hampered by delayed reporting, delayed referral to law enforcement, as well as, sadly, a victim or witness's cognitive abilities.
So because of all those points you just raised, many families worry cases are dropped due to a lack of evidence. What efforts are being made to improve evidence collection and documentation?
Sadly, and rather unfortunately, lack of evidence is a valid reason for failure to criminally charge an accused or to dismiss a criminal complaint prior to resolution. It is a very broad term that can account for a variety of deficits in a case, including lack of a competent victim or witness, lack of corroborating evidence, and an understanding that forcing a competent victim to testify could cause additional trauma. Again, if they're required to testify in court in the presence of the alleged offender, the defendant, and be subject to cross-examination by the defense attorney. Now, law enforcement investigators are trained in various interview techniques designed to take a developmental and trauma-informed approach. Specifically, specialized unit personnel within most of the county prosecutor's offices are trained to engage with persons with intellectual and developmental deficiencies. One example is the Finding Words Child First Forensic Interview training utilized in child abuse and neglect investigations. This forensic method is also employed when interviewing abuse victims with certain special needs. Speaking from my own experience within the prosecutor's office, where I also supervise the Child Abuse and Sex Crimes Unit, we sadly frequently had victims with developmental disabilities, and the Child First Finding Words technique was employed in those instances to obtain an appropriate forensic interview of that victims. Again, Finding Words has also provided more specific training modules on best interview practices to account for individual disability, mental health disorders, language capacity, and cultural background. I would also add that great strides have been made in evidence collection, criminal investigations regarding, again, forensic evidence collection, data, and other high-tech evidence recovery, including cell phone data, cell phone recordings, and trying to recover what was previously considered unrecoverable surveillance or audio-video recordings.
So how do you balance the need to protect victims with the legal requirements that make it so difficult?
So, as both a former prosecutor and for a period of time a criminal defense attorney, this answer is often difficult for the public to understand. A prosecutor's core function is to ensure justice. This does not always equate to criminal prosecution. Due to the potential loss of liberty implications, prosecutors bear a heavy burden in assessing and pursuing criminal cases. They bear the dual burden of protecting the public through prosecution and of protecting the defendant's constitutional rights during that process. Nevertheless, apologize. New Jersey, through the Crime Victims Bill of Rights, is exceptionally victim-centric in its criminal justice approach, with victim witness units established within the Office of the Attorney General and each of the county prosecutor's offices, and those offices being properly staffed with qualified advocates. Victims and their families can be assured that their understanding of the system and comfort level is paramount. County prosecutors represent the people of the state of New Jersey. With this duty, they are committed to securing justice for victims, making them whole to the extent possible, and preventing future victimization at the hands of the accused. In the face of challenges we discussed, law enforcement investigators and prosecutors make every effort to ethically overcome case deficiencies while ensuring that constitutional rights are protected. I would also add that Director Robinson had previously indicated that there are times that OPIA investigators are gutted emotionally by some of the results in their cases, or perhaps their inability to gather evidence in the manner that they had hoped. I can say, based on my experience working with incredibly experienced and talented detectives within the prosecutor's office who handle these types of cases, they too have been gutted when a particular criminal investigation, due to the deficiencies we noted, did not result either in criminal charges or in a guilty verdict. So with that, I completely understand.
So what reforms or initiatives could help make prosecution of abuse and neglect cases in group homes more consistent and successful?
Okay, well, by statute, all New Jersey law enforcement officers must receive autism training. This training is designed to raise awareness, assist in identifying common characteristics or behaviors, provide de-escalation techniques in times of crisis, and guidance on how, to provide for a supportive environment and, most importantly, effective communication during regular encounters and encounters that involve crises. Of course, supplemental and refresher training is always recommended. Perhaps one area that could use additional attention and focus is best practices training for interviewing individuals with ASD, IDD, and other communication disorders who present with difficult to understand speech or unintelligible speech, including adapting interviews for individuals who do not speak. Moreover, assistant prosecutors often benefit from similar training. It is the assistant prosecutor who reviews and oversees the criminal investigations we discussed. And those are the persons responsible for making the determination whether there is probable cause to approve a criminal complaint. Throughout the criminal justice process, assistant prosecutors rather frequently meet with victims, witnesses, and their families in preparation for testimony at motions and at trial. Creating a supportive environment for victims and their families may prove crucial to the case's ultimate resolution and the beginning of the victim's healing process. Additionally, Autism New Jersey highly recommends, through its law enforcement initiative, having a designated point person within each prosecutor's office to serve as an ASD IDD resource for their fellow law enforcement and prosecution personnel handling these very challenging investigations.
Thank you so much, Doreen, for sharing all of this information and everything you're doing, working with prosecutors and the judicial system. There's so much more to come on that front. I really appreciate the concrete, tangible ideas that we can all work on going forward. We're also deeply grateful to Deborah Robinson for helping us understand the state's current safeguard efforts and investigative process. And as I just said, to our own Doreen Yannick for explaining how these cases move through the justice system and how law enforcement works to protect your family members with autism. Safety in group homes isn't just a policy issue, it's deeply personal. All of us are committed to ensuring that your family members are treated with dignity, respect, and compassion. We will continue to work towards solutions that strengthen safeguards and improve oversight and accountability. I want to take a moment to thank the parents and other community members who participated in this webinar. Real progress happens when all of us, parents, providers, advocates, and state officials work together. Please know that Autism New Jersey is here to support you. If you have a follow-up question or concern, please reach out to our helpline, either by phone at 800-4-AUTISM or email information@autismnj.org. Our helpline team has a direct line to our public policy team. They're right down the hall. In fact, all of our public policy accomplishments have been driven by the community's needs as shared through our helpline. I know there were a few questions put into the Q&A feature during today's webinar. Please know that we're reading through all of them and we're going to use them to create more content, to continue the dialogue, and again, working towards more solutions. So thank you so much for joining us. This concludes our webinar. Until next time. Thank you again.